Well, good afternoon again, ladies and gentlemen, and welcome to this second in the Brick Court Public Law Team's webinar programme. I think you've probably already done so, but if you could all mute your microphones and feel free to leave your cameras on or turn them off. What I'm proposing to do, as far as questions are concerned, is if you would like to email me during the course of the seminar, if I'm able to, I will be able to ask some questions at the end of the seminar. So if you send them to my email address, which is on the slide, paul.bowen@brickcourt.uk, I will do my best to put them to our speakers. The United Kingdom has acquired the sad distinction of suffering the highest COVID-19 death toll in Europe. And as the UK moves past the first wave of the crisis, the government's preparation for and response to the pandemic is coming under increasing scrutiny. Criticism has been made of the decision to introduce lockdown measures later than those in other European countries. There have been reports of apparent failures to procure adequate personal protective equipment for NHS staff and other care workers, and sufficient medical equipment for hospitals, particularly ventilators. There are also particular concerns in relation to the death toll in nursing and care homes, and among Black and minority ethnic groups. And against that background, there have been increasing calls for a public inquiry or inquiries. And in this seminar, we're going to look at the extent of the government's duties under Article 2 of the Convention, both procedural and substantive, and how those duties may be engaged in the current crisis. We'll look at some of the claims and procedures that might follow on from the crisis, including inquests, criminal prosecutions, public inquiries, and damages claims. I remember attending an inquest as a pupil back in 1993 into a death that occurred during a police chase, and a young man had died after the police had run him over. At the inquest, which was listed for a morning, the family had no legal aid. There was no disclosure in advance of the hearing, including an expert report that was said to have exonerated the police officers concerned. And although the family were represented by a barrister who appeared pro bono, he was only allowed to ask questions that were very tightly policed by the coroner, and there was no jury. Article 2 has effected a sea change to the obligations of the state, both to protect life and to investigate deaths and near deaths at the hands of state agents. And as you'll hear, those that arise as a result of possible failures by the state to discharge their various substantive obligations under the European Convention. Inquests have been transformed. The government can be compelled to hold a public inquiry under the Inquiries Act, where before it could not. Quasi-tortious liability has been imposed in some areas, such as police investigations, where the common law had avoided imposing liability on public policy grounds. How will these impact upon the government and other public bodies as the immediate crisis begins to pass and affected persons and bodies begin to take steps to enforce their legal rights? Necessarily in the time available, today's lecture will be a broad overview, but we're lucky to have three excellent speakers to help guide us through the thickets. You're first going to hear from Tim Johnston, who's going to talk about Article 2 substantive duties. Tim's a public lawyer with an impressive practice, and he's been in some high-profile cases, some of which you may have heard of, like the first Miller case. Tim's going to be followed by Emma Mockford, who's going to talk about Article 2 investigative duties, in particular the scope for public inquiries. Emma, we were proud to have as the lawyer barrister of the week last week, and she's been involved in some significant public interest litigation, including for the Joint Council for the Welfare of Immigrants and the End Violence Against Women campaign. And then we're lucky to be joined by Anna Thwaites from Bindmans LLP, who's going to talk about Article 2 and inquests. Anna's highly regarded for her work representing bereaved families in contentious inquests and related civil actions and judicial review cases. As I said, at the end, I will aim to put any questions that you have for our speakers. But what I propose to do now is to hand over to our first speaker, Tim Johnston. Tim.
Thanks for that introduction, Paul. So, as Paul said, the core question at the heart of this lunchtime seminar is to ask what obligations might a government owe under Article 2 of the Human Rights Convention in the context of a pandemic. UK citizens are dying at the moment, tragically, in considerable numbers. And the question we want to at least begin exploring is whether it's possible, at least at the conceptual level, to argue that they're dying as a result of the action or inaction of the state in a manner that might give rise to a justiciable legal claim. What, if anything, might the Convention have to say about our current circumstances? Now, I've put Article 2 onto the first slide itself so you can see it and read it. And the thing that strikes me, at least, when you read it, is that the majority of the wording is concerned with circumstances in which the state intentionally takes life, whether that be by way of enforcing a sentence following a criminal conviction, or to quell a riot, or to keep the peace in broad terms. But the critical sentence or phrase for our purposes, and actually if we could go back to the first slide just so that we have it before us, is that very first sentence. Everyone's right to life shall be protected by the law. And that sentence, that phrase, provides the edifice for much or really all of the case law we're going to be talking about this lunchtime. So coming to the second slide, the case law of the Strasbourg Court has been clear that there are two elements that lie within that short sentence. First, there's the positive or substantive obligation to prevent loss of life, where individuals are within the control or the jurisdiction of the state. The second element is the procedural obligation to investigate after an individual has died or where somebody has nearly died. Now, the focus of the second and third talk you're going to hear this lunchtime by Emma and Anna is going to be on that second limb, on the procedural obligation to investigate. But I wanted to start by kicking us off by talking at least briefly about the positive obligation to prevent loss of life. And that's really for two reasons. Firstly, because I think it provides a necessary and a useful backdrop to the procedural element of Article 2. But also, I think, because we're going to begin to see cases, both domestically and in Strasbourg, that rely on that obligation in the context of the pandemic in the coming years. Now, that may well take some time before those cases reach the Strasbourg Court, and certainly some time before they reach judgment in the Strasbourg Court. But I think we are going to see claims that argue that the state has failed in its obligation to prevent death. And it seeks to argue that either the preparation for or the response to the pandemic was inadequate, and indeed inadequate to the extent that it was unlawful. And I think it's worth saying, or fair to say, that I'm already aware in the context of correspondence on behalf of, sent to and from some of my clients, that these are some of the arguments that are beginning to be canvassed in claims that ultimately I think we will see reaching the courts some way into the future. Now, as you can see from the slide in front of you, the positive obligation breaks down into two parts, and I want to start by focusing on the first of those, which is the duty to provide a regulatory framework that prevents loss of life. Now, the classic case in this context concerns, for example, whether or not the regulations or guidance or legislation that sets out the safety regime for certain kinds of industrial work is adequate. Do they provide a sufficient framework to prevent unnecessary and readily anticipated loss of life? Now, it's worth saying, in the context of this lunchtime seminar on the Covid-19 crisis, that that obligation applies in the public health sphere as well. And that's why I picked out this case, Calvelli and Ciglio from 2002, which says in terms that this obligation applies in the public health sphere. So the obligation on the state to set up an adequate framework of regulations and to establish and require working conditions and policies and guidelines that govern what happens in a hospital in order to ensure and protect both the lives of patients and the lives of clinicians working there, will engage Article 2. And you'll see, as is set out right at the end of the quote on the slide, that also goes further, and this is something I think Emma's going to pick up on later, that the obligation also extends to having an effective judicial, independent judicial system that can examine the cause of death after there has been a case where somebody has died. Prosecution of those who are criminally negligent in a healthcare environment is part of the framework of law that protects the right to life under the law. Now, if we can go on to the next slide now, which deals with the second half of this substantive limb, and that's the duty to take adequate preventative operational measures. And I think this is the area in which we're most likely to see some COVID-19 claims. Now, the first case on your slide there, Furdican, Slovenia, I've chosen this example because it strikes me as a really clear example of how wide-ranging and encompassing that obligation to take preventative measures can be. So the basic facts are that the individual in question went rock climbing. There was a mistake by one of their climbing partners. There was an accident, they fell, and they ended up suspended from the rope, seriously injured, hanging off the rock face, in effect. The mountain rescue team was called, and it didn't arrive for a considerable period of time, and the individual in question died before the mountain rescue team could set up its ropes and descend the rock face to reach them and provide medical care. They had originally attempted to reach them by helicopter, but they'd been unable to do so because of the conditions. Now, at first glance, it might seem surprising that the Article 2 obligation has any application here. The individual in question decided to engage in a high-risk activity and injured themselves, but the Strasbourg court was having none of that, and it held that the obligation to protect life extends to the provision of non-core emergency services such as mountain rescue. Now, the second case on the slide, Budieva and Russia, again, I've chosen this because I think it's rather closer to what we're talking about today in terms of COVID-19 and the pandemic. The backdrop to this case was a mudslide in Russia that had resulted in considerable loss of life. And the Russian government's primary argument in the court was that Article 2 is simply not engaged here, and indeed cannot be engaged here, because the loss of life had followed from a natural disaster. And their case was that's just simply not something that can lead to liability on the part of the state. Now, again, the court disagreed. And indeed, they held that this was a case that fell squarely within the scope of Article 2. Depending on the circumstances, the state owes and may breach, depending on the circumstances, a positive obligation to protect its citizens from natural disasters. Now, for obvious reasons, that's not unqualified or unlimited, but the court held that when asking whether or not the state had breached that obligation, it was necessary to consider a really quite considerable range or buffet of factors. You need to look at the domestic legality of the state's acts or omissions, the mechanism and the process by which the state decided to take the decisions that it did. Had they carried out an adequate investigation or study of the risk before it eventuated? What about after it eventuated? What did those investigations or studies say? How complex is the issue? How imminent was the hazard? And how easy would it have been to mitigate the threat in the light of what the state knew? And it strikes me that this is going to provide a fertile ground for Article 2 claims in relation to the pandemic, because what it provides is a framework and a language for assessing and scrutinising the decision-making of governments, both in preparation for the pandemic and also in response to it once it had begun. Did they adequately consider the evidence? Did they prepare sufficiently? Were there things that might have been done which could readily and easily have mitigated the risk? And I think that raises a fascinating scenario where the courts are going to, I think, instinctively want to avoid stepping into this very complicated and highly contentious, highly sensitive political area. But the Article 2 case law does provide a lexicon or a toolkit for assessing and scrutinising the decisions and steps that have been taken. Now, I think I'm out of time, so I'm now going to pass over to Emma, who's going to talk and focus on the procedural aspects of Article 2.
Thanks, Tim. I hope you can all see and hear me. As Tim's foreshadowed, I'm going to be talking about the procedural obligation inherent in Article 2. And the essence of that procedural obligation is a duty to investigate after a death has occurred, why it happened, and in what circumstances. And there are three particular aspects of the duty that I want to talk about before coming on to discuss how this might play out in the context of the current situation with COVID-19. So those are, first, the purpose of the investigative obligation, secondly, when it arises, and thirdly, its contents, how is it discharged in any given case. Starting with purpose then, the jurisprudence of both the Strasbourg Court and the domestic courts here in the UK tells us that the investigative obligation performs a number of essential functions. So first, the imposition of the duty to investigate ensures that state agents or bodies are held accountable for deaths occurring under their responsibility. And perhaps the most obvious example in the case law is when states themselves use lethal force against individuals. They must, of course, be held to account for the use of that force, and accountability will only be ensured if there is an effective investigation. That's the point being made in the Al-Skini case on the slide, which related to the use of lethal force by members of the armed forces against Iraqi civilians. Secondly, by investigating potential breaches of the substantive Article 2 obligations, the state secures their effective implementation. In other words, by having an effective process for investigating whether or not the state has complied with its substantive duties in any given case, you embed those obligations in state agencies and bodies and their decision-making, and hopefully you ensure that more often than not, they are complied with. Thirdly, and this is the point that the domestic courts here have repeatedly stressed, there is a lesson learning function to Article 2. By determining what, if anything, went wrong, and if so, who was responsible, the investigation should ensure that lessons are learnt for the future and further deaths are prevented. And that's the point being made in the Amin and Els cases, which you can hopefully see on the slide. So those are the objectives of having an investigation and it being required to be held under Article 2. And they inform both the scope and the content of the obligation. So looking at scope first, when does the investigative obligation arise? Well, self-evidently, it cannot be the case that the obligation only arises where a breach of one of the substantive duties, which Tim has talked about, is made out. That would defeat the object of having the procedural investigation, which is to ascertain whether or not one of those substantive obligations has been breached in the first place. Rather, the investigative duty under Article 2 arises where death or life-threatening injury occurs in circumstances where the state is or may be in breach of one of its substantive duties. That was the language used by Lord Bingham in the Middleton case, again up on the slide. And that threshold has been considered in subsequent cases. In AP and MP, also known as the Palmer case, Mr. Justice Hinkenbottom, as he then was, said that effectively the question was whether there had been an arguable breach of the duties, which he described as a low threshold. Is it more than fanciful? Something akin, therefore, in domestic law terms to a strikeout sort of application. So if there is an obligation, how is the investigative obligation discharged? What is its content? Well, the starting point is that there is no fixed way in which the investigative obligation has to be discharged. States have a large degree of discretion in fixing the procedure and the process. And importantly, the investigative obligation is itself context-specific. And that's the point being made by Lord Phillips in the quote from the L case, again on the slide. Different circumstances, he says, will trigger the need for different types of investigation with different characteristics. However, as a matter of law, there are certain minimum requirements which any investigation must possess in order to be Article 2 compliant. And some of those are set out in the second case on the slide, the De Silva case. And I'm just going to briefly touch on some of the most important. So first, the initiative to begin the investigation must lie with the state and not with the individual. And the reason for that is probably obvious, but it was explained by Lord Roger in the L case I referred to earlier. Obviously, if a person has died, very sadly, as a result of some breach of the substantive obligations, then he or she will not be able to pursue the matter themselves. and they may or may not have family or friends who are able to raise questions on their behalf. Whether there is an Article 2 compliant investigation can't depend on those sorts of considerations, which is why it's for the state to, of its own motion, start Article 2 compliant investigations where required and where within scope. Second, any investigation which takes place must be adequate. And there are two aspects to that which emerge from the case law. There's an evidence gathering aspect. So authorities must take reasonable steps to secure evidence, including witness evidence, forensic evidence, and if necessary, an autopsy. And there's a substantive aspect, which means that the investigation must be capable of imputing responsibility for the death and identifying and punishing, where appropriate, those responsible, as well as being capable of identifying shortcomings in the regulatory framework. Third, the investigation must be carried out by an independent body or individual. Fourthly, it must be carried out with promptness and what's often referred to in the cases as exemplary diligence. And that again is context specific, because what is prompt will depend on what happened and how large the inquiry needs to be. But generally, the cases emphasise that the evidence gathering aspect of Article 2 in particular must be conducted particularly promptly, given the risk of evidence being contaminated or witnesses' recollections fading over time. Fifth and finally, there must be a sufficient element of public scrutiny, and the investigation must enable the effective involvement of the next of kin. And a good example of this is the Edwards case, Edwards in the United Kingdom from 2002, which related to the death in custody of Christopher Edwards at the hands of another prisoner. The prison service and two local authorities commissioned an extensive and thorough non-statutory inquiry into his death. It took them 2 years. They heard evidence from over 150 witnesses, and they ultimately produced a substantial report which identified a number of shortcomings and missed opportunities to prevent the death of Mr. Edwards. But even then, the Strasbourg court held that the investigation was not compliant with Article 2 because the inquiry sat in private and Mr. Edwards' parents were only able to attend on the 3 days when they themselves gave evidence. So those are the basic criteria which an Article 2 compliant investigation must possess. And in practice, there are a variety of ways in which the UK seeks to satisfy its procedural obligations under Article 2. Chief amongst those is the holding of Article 2 compliant inquests, and Anna's going to be talking about that next, so I won't say anything more about it in this context. But other ways in which the state may satisfy its obligations under Article 2 include by carrying out investigations by relevant authorities or disciplinary and regulatory bodies, public inquiries, which I'm going to come back to. Criminal proceedings may assist in helping the state to complete and comply with its Article 2 obligations. Indeed, in some cases, the state may breach Article 2 if it fails to either investigate or bring a criminal prosecution in circumstances when it plainly should. And finally, in some circumstances, the fact that family members have commenced or intend to commence civil proceedings may also be relevant to assessing whether a further investigation is necessary. So that is the basic outline of the Article 2 procedural obligations. And the further question I want to briefly talk about is what that means in the context of the current COVID pandemic. As Tim said, tragically, we all know that there have been a very large number of deaths from COVID already and ever growing. Anna's going to be talking about some of the statistics in a moment, I think. And in some of those cases, there will clearly be a need for an Article 2 compliant investigation. Importantly, however, that won't be the case in respect of all deaths, probably far from it, because I've already explained that the procedural obligation will only arise when there's an arguable breach of the substantive duty. And for a large proportion of the general public who have been affected by the virus, it may be that there was no such duty engaged. But Tim's already talked about some contexts in which there may have been a duty owed. For example, he talked about the health and social care setting, where he explained there may be a positive duty to prevent loss of life. And in those cases, in the public health setting, there's a line of authority to the effect that deaths which result from, you'll have to excuse the phrase, it's slightly a horrible one, but it's used in the cases, mere medical negligence will not engage Article 2. Instead, to establish a substantive violation of Article 2 in the healthcare setting, it's necessary to demonstrate that there was some kind of systemic failure, i.e. that the regulatory framework failed to ensure proper protection of the person's life. And one can see how that might map onto the COVID situation. If, for example, it was the case that there was no ventilator on a COVID ward by accident and when there should have been, that might be a case of mere medical negligence. But if there's a systemic failure to provide ventilators or other equipment which is needed across multiple hospitals or nationally, then there may be an Article 2 issue. And there are particular concerns in that context with the provision of PPE. And this ties into a case that Tim, Paul and I are currently working on, where the argument is that the state owes a procedural duty to investigate whether there was a breach of the substantive duties it owed to healthcare workers, doctors, nurses, carers, in the procurement and distribution of PPE. Another example, aside from the healthcare setting, may be the management and containment of the virus in prisons. The Guardian was reporting yesterday that a total of 21 prisoners are known to have contracted COVID-19 and died now, as well as 9 prison staff. And in each of those cases, it may well be arguable that the state's substantive obligations have been breached, such that an Article 2 compliant investigation is required. Now, obviously, inquests are one way in which that may be done, and Anna's coming on to that. But the thing I want to focus on for the last minute or so of my time is whether there may be other things the state has to do beyond holding inquests in order to comply with its Article 2 procedural duties. Now, I've already said that what Article 2 requires in its procedural aspect in any specific context will differ. It's very much a context-specific, context-driven inquiry. And of course, it's just a totally unprecedented situation in which we find ourselves now, both in terms of the global nature of the virus, the pace at which it's spread, and the state action which has been taken in response. And in this case, I think there are numerous reasons for thinking that a series of individual inquests may not by themselves be capable of doing the whole job that Article 2 requires. And to give some examples, inquests cannot consider cases where a person did not die. But as I've already explained, Article 2 will be engaged where a person suffered life-threatening or serious injury as well as death. And one would expect that there will be many more of those in the COVID context, as well as actual deaths. And an investigative duty is owed there and can't be discharged by inquests. Secondly, an inquest by its nature examines single deaths or multiple fatalities arising from a single incident, but not multiple deaths with common features, which one might think is the case in the PPE example I gave, or in relation to the prison example. And they would be better looked at on a holistic level. That ties into the question of whether inquests can themselves look at matters of what have been termed high public policy. Scope is always a tricky issue in inquests. Anyone who's acted in one will know that. And persuading a coroner that in order to determine whether a given person in a regional hospital he's looking at died as a result of procurement decisions taken by central government some weeks or months earlier may be difficult and will certainly have variable results. Some coroners may agree that that's something they need to do, others will not. And in that situation, there must be a risk of irreconcilable decision making. Finally, there are timing considerations. I explained at the outset that lessons learning is one of the most important purposes of the procedural duty. And in this case, there's arguably a very strong reason why lessons need to be learned and need to be learned quickly, which is that the government expects or is planning for the possibility, which we all hope won't happen, that there will be a second or third wave to the virus. And in that case, there needs to be I would suggest, a way of rapidly learning lessons, which inquests may not be able to accommodate. So how else might it be done? Well, a public inquiry is an obvious way of doing it, and that's what's being called for by the Doctors Association in the case that I referenced earlier, that Paul, Tim and I are acting on. Other options may be a criminal investigation. There have been reports, for example, that the Health and Safety Executive is considering criminal proceedings against employers who exposed employees unreasonably to the risk of contracting COVID-19. We'll have to wait and see as to whether that's a real possibility. But as I said, if there are bases for thinking that a criminal offence has been committed, then in some circumstances, Article 2 will itself require that a prosecution be brought. I think that's all I've got time for, so I'm going to hand over to Anna, who'll be talking about inquests in more detail.
Thank you, Emma, and thank you, Tim. As Paul said at the start, I'm a solicitor at Bymans, and I normally represent families in contentious inquests. Thank you, Emma, for setting out the procedural requirements, and Tim for outlining the substantive. I'm basically going to be focusing on inquests, which isn't the normal way that the state discharges its Article 2 obligations. I'm also going to touch on the recent Chief Coroner's guidance and some statistics. I'm afraid it's a bit of a whistle-stop tour, but I'll try and stick within my allotted time. Before I started talking about the inquest process, I just wanted to deal with some statistics. Data from the Department of Health and Social Care and Public Health England showed that as of 5 p.m. on the 17th of May, that those who tested positive to coronavirus in the UK, that 34,796 people have died. And this now represents deaths in all settings and not just hospitals. Every death in this pandemic is a tragedy and represents the loss of a loved one, whether that's a mother, a father, a son, daughter, child, or friend. I don't have time to go into detail, but there's a wealth of statistical information regarding COVID-19 on the Office for National Statistics. And my first slide includes links to two reports which I think are worth reading. Unsurprisingly, the Office for National Statistics has identified that healthcare workers are amongst those that are most likely to be exposed to the coronavirus because of physical proximity and exposure to disease in general, although this may be mitigated by the use and availability of PPE. I also wanted to touch upon briefly the deaths, the increase in deaths which are indirectly as a result of COVID-19. This is either because people haven't been going to A&E in emergency situations, or access to life-saving or prolonging life treatment has been stopped during the pandemic. There's also the impact on people's mental health, and the charity Inquest reported last week that there have been at least 8 self-inflicted deaths since prisons went into lockdown on the 24th of March. And it raises real concerns about the impact of isolation and the restrictive regimes on both physical and mental health. And this also applies in psychiatric and immigration detention settings as well. So it's clear that COVID-19 has not only placed a strain upon the NHS, care homes, prisons, but also, as we'll come on to discuss, the coronial system. As a result, this has led to the Chief Coroner releasing new guidance in March and April, and this is detailed in my second slide. I will be focusing on guidance note number 37, which is COVID-19 deaths and possible exposure in the workplace. As Emma has already said, not all COVID-19 deaths will lead to a death being reported to the coroner, an inquest being opened, or engage the procedural obligations under Article 2. It will obviously have to be assessed on a case-by-case basis. I just wanted to flag certain reporting requirements. There is basically a requirement for all COVID-19 deaths to be reported to Public Health England, and deaths may also be notifiable to the Health and Safety Executive. Not all cases have to be reported to the coroner, although where a medical practitioner who's completing the medical cause of death certificate suspects that the person died due to an injury or disease attributable to their employment, there must be a report to the coroner, and this is reflected in paragraph 6 of the Chief Coroner's guidance. The Chief Coroner's guidance then goes on to state at paragraph 7 that where deaths from COVID may have arisen as they've been contracted in the workplace, they may be reported to the coroner, and specifically identifies different categories of workers that this may apply to, and this includes frontline NHS staff, public transport employees, care home workers, emergency services personnel. However, I think it would be difficult to envisage what circumstances such deaths would not be reported to the coroner, given what I was just saying about doctors, that they must basically report deaths where it's suspected that a person may have died of COVID as a result of their employment. And the final thing is also to mention that there is nothing to stop families reporting their concerns to the coroners and asking them to investigate a particular death as well. I'm now going to move on to the coroner's duty to investigate, and that's set out in Section 1 of the Coroners and Justice Act. So a coroner has a duty to investigate a death if they suspect that A, the deceased died a violent or unnatural death, and I'll discuss more about what an unnatural death can be in a minute, the cause of death is unknown, or the deceased died whilst in custody or state detention. And the reason to suspect is a low threshold test. Also, a death may be unnatural, where the death has resulted from the effects of a naturally occurring condition or disease process, but there's some form of human error that contributed to the death. And I've included a quote and the relevant case on the next set of slides. Moving on to scope, once a coroner agrees that an inquest should be opened, many of you will be familiar that it's limited to answering the 4 statutory questions that are set out under Section 5 of the Coroners and Justice Act, namely who has died, when they've died, where they've died, how, and if Article 2 is engaged, how and in what circumstances, which is sometimes referred to an enhanced investigative duty. What is interesting is that the Chief Coroner's guidance is silent on the potential engagement of the procedural obligations under Article 2 in COVID-19 deaths. At paragraph 13 of the Chief Coroner's guidance, it emphasises that it is a matter for individual coroners to decide on the scope of each investigation, but then goes on to state that coroners are reminded that an inquest is not the right forum for addressing concerns about high-level government or public policy, and an inquest would not be a satisfactory means of deciding whether adequate general policies and arrangements were in place for the provision of PPE to healthcare workers in the country or the part of it, and this has already been touched on by others earlier. However, the Chief Coroner's guidance then goes on to state at paragraph 14 that if the coroner considers that a proper investigation into the death requires that evidence or material be obtained in relation to matters of policy and resourcing, and gives the example of the adequacy of provision of PPE for clinicians in a particular hospital or department, it does suggest that potentially the inquest could look into these matters, or that the coroner may choose to suspend the investigation until it becomes clear how such inquiries can best be pursued. My reading is that the guidance does not suggest that coroners cannot consider PPE issues at all. Local policies, such as within a particular trust, or the way in which policy has been implemented in practice, would be within scope. Also potentially where there's been issues in terms of the supply of PPE as well. Also, practically speaking, it may not always be easy for coroners or inquest lawyers to distinguish between local, regional and national PPE supply issues. One of the difficulties in terms of suspension of the coronial process is that there's been no government announcement at the current time in terms of a public inquiry that would be able to deal with some of these issues that the Chief Coroner is suggesting that coroners may not be able to investigate as part of the inquest. I should also emphasise that the Chief Coroner's guidance does not and cannot alter primary duties of a coroner to investigate appropriate deaths, either under the Coroners Justice Act and to comply with the procedural obligations under Article 2 to carry out an effective investigation. Just to touch on briefly in terms of Section 30 of the Coronavirus Act, it removes the requirement for an inquest to be held with a jury if the coroner has reasons to suspect that death was caused by COVID-19. I also wanted to touch very briefly upon the conclusions once an inquest has perhaps been listed and the evidences have been heard. Often people will refer potentially to a filtering or funneling when it comes to conclusions, and completing the record of inquest. The test for causation is set out in Tainton, and the question is whether on the balance of probabilities the conduct in question more than minimally, negligibly or trivially contributed to the death. However, it's worth flagging the case of Lewis that also states that possible conclusions may be left, and in Tainton it referred to serious failings ought to form part of a narrative conclusion given that they form part of the circumstances of the death, even if not causative. And so potentially these cases where it may be difficult to establish on the basis of Tainton the causation test, there is still an opportunity for perhaps issues to be reflected in the record of inquest given the circumstances. I also wanted to briefly touch upon Regulation 28 reports, which the coroner has a duty to make to prevent future deaths if they hear evidence at the inquest. And this is part of the learning lessons which Emma has already touched upon. My final points are potentially there may be legal aid funding available for families if there's an arguable breach of Article 2. And also to touch upon the fact that the coronial courts are underfunded and often under-resourced, and so there are potentially limitations in which Emma has already touched upon in terms of individual inquests with limited resources that are dealing with some of the same repeated systemic issues which may be being dealt with up and down the country. And this is why many people consider it's desirable and possibly inevitable to that there should be a public inquiry. However, at the current time, the inquest is the only mechanism available for families of those that have lost their lives on the front line to hold the state to account and potentially to answer their concerns regarding PPE and failures in testing. Thank you.
Well, that's been incredibly helpful. Thank you, Anna, and Tim, and Emma. I hope you can all hear me, and you can see the last slide on the PowerPoint presentation. What I suggest, if you want to know a little bit more about this subject, you'll be able to get hold of the PowerPoint presentation from the website later today. You'll see on the website, on the PowerPoint, there's a reference to an article on the UK Constitutional Law website, a blog that I wrote about these issues a couple of weeks ago. So I encourage you to go and have a look at that if you want to find out a little bit more. I've given our contact details in the slide. Of course, if any of you have any questions for any of us, then please feel free to send them in. We haven't really got very much time for questions. We've had to absorb an awful lot. The state owes operational duties to certain groups, employees, those for whom it's assumed responsibility for. It owes systems duties. It might owe a duty to provide information, all of which, if arguably breached, give rise to a duty to investigate, and that duty to investigate may be discharged in a number of ways. It may require an inquest, it may require a public inquiry, it may require prosecutions, and it looks like we will see litigation arising from the COVID pandemic. We'll see civil actions for damages, potentially public inquiry, certainly a number of inquests, and very likely, or very possibly anyway, some prosecutions. I think, given where we've got to with the time, I'm going to draw things to an end. There was one question that was sent in by one of our delegates, but I think it's been answered, which related to the duty of care owed to prisoners. And I think it's right to say that prisoners are among the vulnerable groups to whom the state owes particular duties to provide health care, and therefore Article 2 will be engaged in relation to any COVID-related deaths of prisoners. So what I propose to do, ladies and gentlemen, is to thank you for joining us today. I hope you found that a stimulating series of presentations. Your interest, I'm sure, will have been piqued, but I'm sure you will still have other questions given the scale of the subject. But as I said, do please contact us if you'd like to know more. I'd like you to join me in a virtual round of applause for our speakers and to say thank you, and it's goodbye from us.